Welcome, everybody, and we're thrilled to have you here. Thank you for bearing with us for a moment as we're all getting used to the new normal and the new technology. Sometimes there are some glitches, so I appreciate your couple minutes of waiting, and it also gave us an opportunity to make sure that everyone could join us who wanted to. So this morning, we're very thrilled to have an esteemed attorney with us to be able to talk about pandemics and planning, steps you can take right now to protect your estate. My name is Elizabeth Aloni, and I'm with Schneps Media. We're the largest local media company where we serve Queens, the Bronx, Westchester, Manhattan, Brooklyn, and Long Island. And today we're thrilled to have Anthony Enea, who's the managing member of Enea, Scanlon, and Siriganano. And he's an elder law trust and estates law firm with offices in White Plains, New York, and Somers, New York. For over 30 years, Mr. Enea has devoted his practice to educating and protecting the rights of seniors, the disabled, and their families from the cost of long-term care. Mr. Enea and his firm concentrate their practice on elder law, asset protection planning, Medicaid applications such as nursing home and home care, wills, trusts, and estates, guardianships, and special needs planning. Mr. Enea is a certified elder law attorney by the National Elder Law Foundation, is the past chair of the Elder Law and Special Needs section of the New York State Bar Association, past president of the Westchester County Bar Association, and is the current president of the Westchester County Bar Foundation. He's the author of hundreds of published articles and has been selected as a super lawyer for the 11th consecutive year and has been selected for inclusion in the Best Lawyers of America as an elder law attorney for the 6th consecutive year. We certainly are pleased to have such an expert with us to provide you some super important information, certainly during COVID, but during any time, the importance of estate planning. So please take it from here.
Thank you, Elizabeth, and I hope all of you are doing well, and I apologize for any glitches in getting the program started on time. But as Elizabeth said, we're definitely in a new normal. So today I'm going to focus the program on estate planning during a pandemic. And it's really just not for a pandemic, but it's the objective is to tell you what you should be thinking of so that you don't get caught unprepared if something happens to you, whether you were to get sick, be out of work for a significant period of time, or God forbid, pass away. These are the issues that you're going to have to deal with. So let's get started and talk about the impact of COVID-19 today. So everybody should be seeing the slideshows. And what is the impact? Well, obviously there is a personal impact: illness, fear, stress, lack of exercise, depression, overeating. Everybody is going through some level of either physical and psychiatric change as a result of COVID-19. It's a different world. Obviously, if any of you have been out shopping and gone to a supermarket, you know that things are not the same. Things are definitely different. The supermarkets look different. The cashiers, their environment's different. Everybody's wearing a mask, and it kind of gives you almost a surreal feeling. So what we're going to try to do today is to put your mind at ease about the things that maybe you have already done or maybe you haven't done that you should be doing. So many of you are feeling the financial impact of COVID-19, being a loss of job, you've been furloughed, you've been laid off. So these are things that are serious. Many of us have felt a decrease in our stock portfolio. We don't know what the future holds for the stock market, our investments, our retirement plans. So there's a lot of uncertainty. But in spite of all this uncertainty, there are things that we can do. There are steps that we can take today. And I like to refer to them as proactive steps. What can you do now to protect yourself in the future? What steps can you take? Well, the first thing you should do is go review your estate plan. If you have an estate plan that you did many years ago, it may need updating. The people that perhaps you selected as beneficiaries, as executors of your plan, may not be the same people that you want to handle your affairs in the event that you die now. So you may want to change who the executor or trustee of a trust is. Additionally, You may have had falling out or a change in relationship with the individuals that you named as beneficiaries of your plan. So it's a very good idea to always look at your plan every 5 to 6 years to make sure it's updated. Additionally, during a 5 to 6 year period, there are going to be changes in the law that impact the documents that you have prepared. For example, I have a lot of clients that have been calling me recently that haven't updated their plan in 20 years. Well, the documents that we're doing now are completely different than the documents that we did 20 years ago. The other thing that's a major consideration for most individuals, for most Americans, is how can I protect my assets from the cost of long-term care? Very few of us will be impacted by estate taxes. Estate taxes are there, they exist, but they're really a problem for the very affluent. Just to give you an example, the federal estate tax credit right now for 2020 is $11.58 million per person. The New York estate tax credit is $5.85 million per person. These estate tax issues are only going to impact a very small portion of our population in the United States. The vast majority of the population, the main thing that will impact their life savings is the cost of long-term care. Other factors you want to look at. If you have a last will and testament, you should know that if you die with assets in your name alone and you have a will, or if you don't have a will, your estate is either going to have to go through a probate proceeding or an administration proceeding. Probate is when you have the will has to be admitted to probate. It has to be accepted by the court in the county where you reside, the surrogate's court or probate court in the county where you reside. So if you die with the last will and testament and you have assets in your name alone, that will is not valid until it's been accepted to probate. The cost of probate and the time delays of probate are significant. You should know that your family is going to have to hire an attorney to probate the will. There are going to be filing fees with the court. And the average time to probate a will is anywhere from 9 months to 1 year. So avoiding probate is a factor that some individuals are very concerned about. So let's take a look at the estate planning documents everybody should have. And a lot of these are what are called advance directives. For example, a power of attorney is an advance directive, a healthcare proxy, a living will, a HIPAA form. They're advance directives. Then you have the last will and testament, a revocable living trust agreement, and a Medicaid asset protection trust. And we're going to go over and review all of these documents. So let's start off with the healthcare proxy. What does a healthcare proxy do? A healthcare proxy allows you to select an individual, in New York, one person at a time, to make medical decisions for you when you're no longer able to make them. It's the only document recognized by law other than a MOLST document, it's called a MOLST, where you can select somebody to make medical decisions for you. That's an important decision, the decision of who you select. Is it somebody that is going to implement your wishes? Is it somebody that you've spoken to and told them what your wishes are about medical treatment in the event that you can no longer make decisions, end of life decisions? In the healthcare proxy, you can be as specific as you want about the type of care that you want to receive, or as broadly vague as you want. In fact, the form says, unless otherwise specified herein, my agent knows what my wishes are. I prefer to leave the document as vague as possible and give the agent the authority to make the wishes and to know what your wishes are and to make the decisions. Because if in fact you are very specific and you've left out a way of keeping you alive that exists in the future, that could be problematic. So no matter what age you are, whether you're 50 years old, 25, or 85 years old, a healthcare proxy is a very important document. It allows somebody to make medical decisions for you when you can no longer make them. Extremely important document. A HIPAA form. HIPAA form, the actual language in the HIPAA form is kind of built in to the healthcare proxy. the healthcare proxy in New York has what's called a HIPAA authorization. And that HIPAA authorization allows you to select somebody to have access to your medical and hospital records. Very important. I like to do a separate HIPAA authorization form. And the reason why I like to use the separate form is because in that separate authorization form, I can identify the individual I want to select to have access to my medical records. And more importantly, I can actually broaden the type of records. There are provisions that you can initial and select. For example, that your agent can have access to your drug abuse records, your alcohol abuse records, your psychiatric records. So the actual form itself, in my opinion, is much better than just having the healthcare proxy with the authorization language in the healthcare proxy. Okay? Living will. Living will is not a document that's recognized by statute in New York. A living will is just a statement of your intention not to be kept alive by extraordinary measures. The document says, if I am brain dead, comatose, and not otherwise able to make decisions, and I have no hope of recovery, then my wish is not to be kept alive by extraordinary measures. It kind of works like a belt and suspenders approach with the healthcare proxy. In the healthcare proxy, you state, this is the individual that I want to make medical decisions for me if I can no longer make them. And that person would be able to communicate your wishes to your physicians and the hospital. And the living will comes into play if, for example, there is an end of life issue. The living will can then be used by your agent to demonstrate to the hospital, see, not only did she tell me she did not want to be on a ventilator or respirator or any other type of mechanism to keep her alive if she was seriously ill, brain dead, comatose, but she signed a living will that demonstrates that she did not want to be kept alive or he did not want to be kept alive by extraordinary measures. So whether or not you have a healthcare proxy, you should always consider also having a living will if your intention is not to be kept alive by extraordinary measures. Next document, durable power of attorney. In my opinion, this document is perhaps the most important document that you'll execute during your lifetime. It's a document where you appoint somebody to be able to handle your financial affairs. Durable, in the phrase durable power of attorney, means that that power of attorney survives your subsequent incapacity. So for example, if I sign a durable power of attorney today and I have a heart attack or a stroke tomorrow, that power of attorney is still valid even though that I have become incapacitated. A power of attorney is primarily and generally only for financial affairs. There are some states that have powers of attorney that are combined with healthcare proxy. I prefer not to do that. I prefer to have a separate durable power of attorney document. This document can be drafted as broadly or as restricted as you want. I prefer to draft a broad power of attorney. Why? Because I don't want the client to handcuff their agent. I've seen over the last 30 years of practice so many powers of attorney that were inadequately drafted. And then when the agent needed to use the power of attorney, they were not able to do some of the most basic things to be able to protect the assets of the individual, and including gifting of assets. So let's talk a little bit about the form itself. You have the standard language in the power of attorney that allows the agent to do, banking, real estate transactions, business operations, claims and litigation, healthcare billing, purchase, sale of goods. That you'll find in the standard form power of attorney. And generally the way it's done is you don't necessarily have to initial every box. You initial a box at the bottom that covers all of the powers that are referred to above that power. Then you can actually modify the power of attorney in New York. You can have a section where you amplify the statutory powers. And those modifications can contain trust transactions, entry into a safe deposit box, give your agent the authority to retain a lawyer, retain an accountant, enter into personal service contracts. Also, your agent can make statutory elections. For example, the right of election to claim assets from your spouse's estate, or to do a disclaimer or a renunciation as to an estate. Then if, for example, the agent is handling a Medicaid application for you, in the modification section, the agent can be authorized to execute the spousal refusal form. The agent can also be authorized to prepare and file a Medicaid application on your behalf. One of the most recent modifications that we've made to the power of attorney form is vis-a-vis digital assets. A lot of individuals have a lot of digital assets. They have online bank accounts, they have Bitcoin, they have online photographs, online computer programs that they use for their businesses, and giving your agent the authority to access those digital assets is very important. Then the next part of the power of attorney, and we'll get to that, I'll get to the will in a second, is the gift rider. The gift rider is perhaps the most important part of the power of attorney. Everybody should have a power of attorney that allows your agent to make gifts of your assets. So in the gifts rider is where we give the agent the authority to make gifts. And I like to draft that gift rider as broadly as possible. Why? I don't want to handcuff your agent. I want your agent to be able to do virtually everything that you can do. For example, husband and wife, they own a house jointly, or the husband has a bank account in his name alone. If there is not a power of attorney with a broadly drafted gift rider, then the spouse of the individual who is incapacitated cannot transfer the house into her name, can't transfer bank accounts into her name, and then be able to do, for example, a Medicaid application. Because if you have assets in your name and you're incapacitated, you're unable to get Medicaid. And I'll talk about Medicaid in a little bit because it is a very important topic. So a broadly drafted power of attorney with a broad gift power is essential. I've seen too many cases where the power of attorney did not have a significant gifting provisions in it, did not have a gift rider, and that resulted in the family having to go to court to do a guardianship proceeding, a time-consuming and expensive proceeding, to be able to move assets out of the individual's name into the name of the spouse or other loved ones. So a power of attorney with a gift rider is very important. Last will and testament, perhaps the most basic document that everybody should have. What is a last will and testament? A last will is a writing where you specify whom you want to receive your estate upon your death. You state the individuals. You can state in percentages, you can state in dollar amounts, you can make a specific bequest. You could state that they get the assets outright or in a trust in your last will. You can create a trust for your loved ones. In the last will, you can do estate tax planning. It's a very important document. But as I said earlier, one of the downsides of having a will is that the will, in order to be valid, has to be admitted to probate, and the will only controls assets in your name alone. It does not control assets in a joint bank account, an account that has a named beneficiary. It does not control assets in your 401k or IRA that have named beneficiaries. So while it is an important document, it should be kept in mind that it only controls assets in your name alone, and it only controls, it only is valid once it is admitted to probate. So you have the named beneficiaries. They can be individuals, they can be charities. You could actually have a provision in there for to take care of your pet. We can build in, and we've been doing a lot of these lately, is building in a pet trust for our clients. Our clients want to make sure that upon their demise that their pets are provided for. And again, in the will, you can be very specific as to whom you want to receive your tangible personal property. your furniture, your jewelry, clothing, or you can be very broad and general about that. You can have it divided amongst your heirs. Again, with real property, your house, you can be specific as to whom is to receive your house, your condo, your co-op. So it's an important document. Everybody should have a will. In the will, one of the most important considerations is who's going to be the executor of the will, who is going to be the individual that is going to handle my affairs and handle my estate upon my death. You would like to name somebody perhaps who is a little younger than you, in good health, somebody that is financially astute, somebody that understands perhaps investing money, how to maintain assets, is good with, marshaling assets, being able to handle an estate, because there are some complexities to it. There is work to be done, and you really do want to have an executor that is financially astute, and most importantly, somebody that you have a lot of trust and confidence in. You want somebody that you know is going to do the right thing. Okay? So that's the basics of a will. A revocable living trust and probate avoidance. A lot of my clients are very concerned about probate. They say to me, Anthony, I had to do probate when my dad died or my mom died, and it was a very cumbersome and expensive process, and it took forever to complete the process from beginning to end. The probate process in Westchester County is a process that takes anywhere from 9 months to a year, assuming that nothing goes wrong, that there's no complications, no problems. Now, in light of COVID-19, I think that process is going to take much longer. The courts have not been open. They're going to be overwhelmed now with a number of estates of individuals who passed because of COVID-19 and other reasons as well. So I see a significant backup in the surrogates courts throughout the state because of COVID and what's happened. A revocable living trust is not subject to probate. It avoids that whole probate process. And in a revocable living trust, you can basically do everything that you do in a will. So let me give you the general parameters of what a revocable trust is. A revocable trust is an agreement between the creator of the trust and the trustee. Well, in New York, you can be the creator of the trust and you can be the sole trustee. And then you can have alternate trustees, or if you want, from the very beginning, you could have a co-trustee. When you have a revocable trust, think of it as a canister, as a container. The trust only controls the assets that are titled in the name of the trust. So if you have a brokerage account, a house, a condo, or a co-op, if you want the trust to be able to control those assets need to be titled in the name of the trust. So your bank accounts would not say John Smith, they would say the John Smith Revocable Trust with John Smith as the trustee. Many times a husband and wife would like to do one revocable trust for both of them, where they're both the creators and then they're the trustees. And if they have children, they'll name the children as the alternate trustees. During your lifetime, you have full control over the assets in the trust. They're your assets. They don't have a separate federal ID number. They use your own social security number. And for income tax purposes, they're treated the same way as your assets are treated. If there's income on the assets in the trust, they're taxable in your personal return. And you have full control. You can modify the trust, you can revoke the trust, you can remove assets to out of the trust, and you can add assets to the trust. The moment you die, or you and your wife both die, then the trust terminates. And once the trust terminates, it becomes irrevocable. And now the alternate trustees would step in, pay any of your bills, and make the distributions of the assets. For all the assets that are titled in the name of the trust, and whatever other assets that you have, such as an IRA or 401k or life insurance that have named beneficiaries on them, those assets will pass automatically by operation of law to the named beneficiaries, and then the assets in the revocable trust will go to the beneficiaries named in the trust outside of probate. There will not be a probate proceeding for those assets that are owned by the trust. So the key components of having a trust are A, executing the trust, making sure it's fully executed, and funding the trust. It is very important that the trust be funded with the assets. And funding means naming the assets that you own in the name of the trust, retitling the assets. Not a very difficult process, especially with a bank account, a brokerage account. We generally handle for the client the retitling of the condo, the house, and the co-op. So that is something that is done as well. And obviously, if you own a co-op, the co-op board would have to approve the transfer of the co-op to the revocable trust. But if you have a revocable trust, when you die, there's no need to go through the probate process. You're not going to have this 9-month to 1-year process. You're not going to have the filing fees of the court. You're not going to have any possible delays that result from the court. And it's a much smoother and a much easier process. This vehicle has been used for decades out in California and many other states. It's an excellent vehicle. Okay? That's the revocable trust. What is the long-term care planning options that we have? Because I think for most Americans, the concept of protecting assets for long-term care is probably the most important concept that they need to become familiar with. So there are different ways of protecting assets. Long-term care insurance is one of them. There are many excellent long-term care insurance products out there. But remember, in order to be able to get long-term care insurance, you have to be insurable. And and when you get older, obviously the policy premiums are more expensive. And I believe that after the age of 70 or 71, you no longer can go out and buy long-term care insurance. And if you did, the expense would be prohibitable. As you get older and you have more illnesses, your insurability becomes lesser and the premiums go up. So there are different types of policies. There are straight long-term care policies, and then there are hybrid policies where you can buy a policy that gives you both long-term care coverage and life insurance coverage. If you don't have long-term care insurance, what do you need to do? Well, you need to think about what steps can I take now while I'm still healthy to be able to protect my assets? Why do you want to protect and shelter your assets? Well, you don't want those assets being subjected to the cost of long-term care because the cost of long-term care is significant. And you want to be able to one day become eligible for Medicaid, whether it be Medicaid home care or Medicaid nursing home. So the type of planning that we do for individuals is a lot of planning for Medicaid asset protection planning. What steps can I take now to shelter my assets from the cost of long-term care? How can I make that piece of my pie smaller so that the cost of long-term care doesn't devour the entire pie? Well, you can self-fund for your long-term care. Very few people have the ability to do that. You have to be very affluent to be able to self-fund. Obviously, you can rely on family assistance for long-term care. Very difficult, very stressful when someone has to take care of a senior who has, multiple problems such as Alzheimer's, dementia, Parkinson's, they're incontinent, they need help with walking, dressing, feeding, bathing, toileting. Having family members involved is great, but it could be a very taxing and stressful experience for the family members. Then obviously you have long-term care facilities, nursing home. Nursing homes have now become, much more complicated in light of COVID-19. I think the nursing home industry is going to find itself in a period of transition. They're going to have to change the model for how they give care. Remember, when we hear about, COVID-19 spreading rampantly in a nursing home, the reason it does is because of the very nature of how the nursing home is set up. The nursing home is created for communal living. There is communal dining. There's a community dining room. There is a community activities room, a movie room, an entertainment room. where they play bingo. So all of these activities bring people together, and they're really an incubator for creating and spreading a virus such as COVID-19. So going into the future, I see a significant change in the way nursing homes are going to be operated, created, and modeled. Same thing for assisted living. And I think, and at least in the immediate future, there is going to be a much more push for individuals to age in place. For the last decade, I would say seniors have preferred to age in place, to remain at home. And I think we're going to see that trend continuing. Fortunately, in New York, we have had a very good Medicaid program, but there are some changes coming about in October, which I'm going to discuss briefly. Okay, so the cost of long-term care. In New York, particularly Westchester County, New York City, the 5 boroughs, the cost of long-term care is significant. If you're going to be going into a nursing home and you don't have long-term care insurance, you're not eligible for Medicaid, you can anticipate spending anywhere from $400 a day to $500 a day. The cost can be anywhere from $177,000 a year to more than $200,000 a year on a private pay basis in a nursing home. It's much more expensive in New York City. Long Island is over $500 a day from what I'm hearing from my colleagues. So it's a much more expensive proposition depending on where you are. And I think there's also going to be the factor that people are not going to want to go into a nursing home right now. But again, for some individuals, there is no option but a nursing home. We have to remember that. Some individuals are just too ill to stay at home, even with care, even with 24-hour care. Home care is a little bit less expensive, but it still is significant. If you're going to be paying for an aide to come to your home and you're going to be paying privately, you can anticipate spending about $21 an hour. And if you're receiving 8 hours of care a day, 7 days a week, that cost would be easily $60,000 plus. So you're going to see a significant expense for home care, again, if you're not eligible for Medicaid. And if you need 24/7 home care, you're talking about anywhere from $80,000 to $100,000. Okay, so how do I limit the cost of my care? Well, Medicaid eligibility is one of them. Long-term care insurance, I've talked about that also. There's the state certified policies where you buy a policy that's been certified by the New York State Insurance Department, and that once you exhaust that policy, you become eligible for Medicaid, no matter how much savings you have. The policies have not done well. They haven't sold well over the years because people wanted flexibility, and originally the policies did not give flexibility. They're given more flexibility now. You can have straight long-term care insurance where you pay X number of dollars per year, and that gives you a daily benefit of Y dollars per day, either for nursing home or home care. Or you could have the hybrid policy that I mentioned that provides both long-term care insurance and life insurance. Again, factors in getting the insurance: insurability. The older you are, any medical conditions you have, you may not be insurable. And as you get older, the cost goes up precipitously. It's a significantly higher cost as you're getting older to do it. Ideally, you want to buy this insurance probably in your 40s and early 50s. As you're getting closer to 60, it becomes much more expensive. Advanced long-term care planning, probably the most important thing you can do. And I'll get into the details of that in a little bit. So let's talk about the home care program in New York. New York has had a very good home care program for many years, and I think the program will continue to be very good. Unfortunately, because of budgetary impact and the budget in New York State and the deficits, New York State has just passed a new law that says as of October 1 of this year, 2020, if you make a transfer of assets and for purposes to qualify for Medicaid, that there is going to be a 30-month period of ineligibility. So presently, there is no look back for Medicaid home care, and there hasn't been a Medicaid look back period for home care services. So for home care services is where an aide comes in to help you with bathing, dressing, feeding, toileting. You have to need assistance with activities of daily living, and you also have to meet the financial test and the federal requirements, the basic requirements. But now, starting in October, if you were to give assets away on October 1st or after, and then apply for Medicaid home care, you would be disqualified for Medicaid home care for 30 months. We believe there are things that can be done to shorten that period, including doing what's called a Medicaid crisis plan. However, you do have that look back period. Many of my clients have become aware of this law and they're saying to me, Anthony, what should I be doing? Well, the thing that you really need to do is get the planning done before October 1st. Transfer assets to a Medicaid asset protection trust before October 1st, and then you will avoid having a look back period commencing on October 1st. So doing the advanced planning and doing it now and prior to October 1st has become an urgent need for many seniors, especially if they anticipate needing Medicaid home care in the near future. So if you're a senior and you're in your 70s or 80s, or you have a loved one, a family member that's in their 70s and 80s, and they anticipate that they will be needing long-term care services at home in the next couple of years, and they still have assets in their name that they haven't tried to protect, now is the time to try to protect those assets before October 1st. What are the federal requirements for Medicaid eligibility? You have to be a U.S. citizen or a permanent lawful resident alien. You have to be 65 years of age or older or disabled as defined by states' Medicaid's provisions. And you must be a resident of the state and county where the application for Medicaid is made. New York does not have a durational residency requirement. All you have to do is be in New York with the intent to remain, and then you can apply for Medicaid in the county where you're residing. So we have a lot of clients that retired to Florida, and they even homesteaded in Florida, elected to be a Florida resident for tax purposes. But now they're older, they're more infirm, they need help with care, they decide to come back to New York, and they can apply for Medicaid in New York if they are here with the intent to remain. So it's a subjective test. It's not a difficult test to meet the requirements, okay? Medicaid nursing home. Medicaid nursing home, at least for the last decade or so, has had a 5-year look back period for purposes of when you make transfers and eligibility for Medicaid. So if you are a senior and you want to apply for Medicaid nursing home, and within the last 5 years, 5 years before you're applying, you've made gifts of assets away, and you've made these what they called uncompensated transfers of assets. Well, they have to be disclosed to Medicaid, and those transfers may disqualify you for Medicaid for 5 years. They create what's called a 60-month look-back period. So it's very important to look at when you've made asset transfers if you're applying for Medicaid nursing home. So that 5-year look-back period generally applies to all uncompensated transfers unless they're exempt transfers. And I'm going to talk to you about what those exempt transfers are in a few seconds, okay? What are the eligibility requirements for Medicaid? And the eligibility requirements depend on whether you're single or you're married. So if you're a single individual and you're applying for Medicaid home care, you cannot have more than $875 per month of income plus a $20 disregard. And then if you're going to apply for Medicaid nursing home, Medicaid will take all of your income if you're single, with the exception of $50 a month. In order to be eligible for Medicaid, and you have savings, your savings have to be $15,750 or less. If you have more than $15,750 when you're applying for Medicaid, and they call that a luxury fund, then you are not eligible for Medicaid. You can also have an irrevocable burial trust. You can go out and prepay your funeral. But other than that, you're not allowed to have liquid assets, liquid non-IRA assets. It's important to note that Medicaid does not count your IRA, 401k for purposes of eligibility, so long as that IRA and 401k are in payout status. What does that mean? That means you must take your required minimum distribution. So no matter what age you are, if you're applying for Medicaid, you must take the required minimum distribution from your IRA, even though you haven't reached the age of 72. The face value of that IRA is not counted. And when you die, presumably you're going to have named beneficiaries and named alternate beneficiaries on that IRA. And then that money is going to go to those individuals by operation of law, and Medicaid will not be able to have a claim on that IRA money. However, if you don't have a named individual as the beneficiary of your IRA and you've received Medicaid benefits, then that IRA will go to your estate and Medicaid will have a claim against your estate. In New York, Medicaid has claims and liens on all assets that are in your name alone on date of death. Probate assets. Probate assets are subject to Medicaid claims. Another reason why it's best to have a revocable trust and or a irrevocable Medicaid asset trust. If you're a couple and you're residing in the community and you want Medicaid home care, you're not allowed to have more than $1,284 per month of income, plus a $20 disregard, and the couple is allowed to have $23,100 of non-IRA money. A lot of you are probably wondering, well, what about the house? Well, if you're living in your house is your primary residence, it's considered your homestead, and it does not affect your eligibility for Medicaid. However, if you're single, or even if you're married, the possibility exists that when you die, that house will be part of your probate estate, and as part of your probate estate, it will be an asset against which Medicaid has a claim. So that's something that you need to keep in mind. The house is probably the most important, the largest asset that most individuals have, and protecting that house and making it a non-probate asset outside of the scope of a potential Medicaid claim is very, very important. Okay? So income, if you're going to be in a nursing home, you're going to be at home, income, even though there's this limit of $895 per month, there are ways to protect your income. Virtually all of your income can be protected by enrolling in a pooled community trust. It's a way of sheltering the income and being able to use the income while you're at home to pay for your expenses. Okay? Now, what if one spouse is going into the nursing home and the other spouse is going to remain at home? The spouse that's remaining at home is considered the community spouse. They're allowed to have up to $3,216 of income, and they're also allowed to have savings, non-IRA, of anywhere between $74,820 and $128,640. That's the maximum community spouse resource allowance, and that allowance is the maximum that New York allows, $128,640. So what happens in a normal situation when one spouse needs to go into a nursing home and the other spouse is going to remain at home? Well, if the spouse that's going to remain at home has more than $128,640 of savings, in order for them to be able to get their ill spouse eligible for Medicaid, they're going to have to do spousal refusal. And spousal refusal is permitted in New York for both Medicaid home care and Medicaid nursing home. And this new law that goes into effect on October 1st has no impact on spousal refusal. So, typical scenario, let's say for argument purposes, I have to go into a nursing home and I have $400,000 or $500,000 in a joint account with my spouse, or a couple of $100,000 in a joint account with my spouse, and I have a house with my spouse. We would want to transfer all of my assets other than my IRA to the well spouse. So the house would be moved to the well spouse, and the monies would be moved to the well spouse. And this is where you could see how the durable power of attorney comes into play. Now, with the broad gifting powers, now the well spouse has all the money and the house in their name, but they have more than the $128,000. Now, for me to be eligible for Medicaid, my spouse has to refuse to support me. My spouse is going to say to Medicaid, I refuse to use my assets and my income to support my spouse. They sign a spousal refusal letter, and then the ill spouse or the ill spouse's personal representative has to sign an assignment of support. They have to, the ill spouse has to assign their right of support from their spouse to Medicaid. And that is what triggers Medicaid's right to pursue a claim against the refusing spouse. But when you do spousal refusal, Medicaid can only pursue a claim for the amount of benefits that they've provided and paid for. So the big advantage of doing spousal refusal for Medicaid nursing home and Medicaid home care is that even though Medicaid can sue the refusing spouse, they can only sue them for the value of the services provided by them. So Medicaid doesn't pay the nursing home the same amount that you and I pay. They pay them a reimbursement rate, and the reimbursement rate is significantly less than what you and I would pay privately, probably anywhere from 50 to 60% less. So if Medicaid has a claim against the refusing spouse, it is only a claim for the amount that they paid. And that applies also to the home care scenario as well. Okay, so what can you do? You're a typical middle-class New Yorker, lower middle class, upper middle class. You're not a millionaire. You don't have multiple millions of dollars, and you're concerned about the cost of long-term care. What can you do? Well, the one thing you want to do is you want to start creating look-back periods. You want to take assets out of your name and disqualify yourself for Medicaid while you're still healthy. You want to create that look-back period, whether it's the coming in October, the 30-month look-back period for Medicaid home care, or the nursing home look-back period of 5 years. So what happens is when you go to apply for Medicaid, Medicaid asks for 5 years worth of bank records if you're applying for Medicaid nursing home. After October 1st, and you're applying for home care Medicaid, they're going to ask for 30 months worth of bank records. But creating that period of ineligibility, triggering that period of ineligibility by creating the look back, that is critical. That's what you want to do. And that can be created by making a transfer of assets outright to your children, or by making a transfer of assets to a Medicaid trust. And the Medicaid Asset Protection Trust, which is a very, very good vehicle to protect assets for Medicaid. So when does the look back period commence? It commences on the first of the month following the date of the non-exempt transfer. So if I were to make a transfer of assets in the month of May, the look back period starts on June 1st. That's when the period of ineligibility commences. So if you, for example, wanted to do Medicaid planning and you were going to do it this summer, June, July, and August, the month after you actually funded the Medicaid trust, that's when the look back period will commence. 5 years for nursing home Medicaid. Right now, up until October 1st, no look back period from home care Medicaid. As I've said earlier, aging in place and getting care at home is predominantly what most of our clients want. So creating that look back period before October 1st is critical if you anticipate needing home care in the near future, or your loved ones need home care in the near future. The transfers. There are transfers that are exempt, and then there are transfers that are non-exempt. The transfer of an asset to your spouse is exempt. Blind or disabled child is exempt. Transfer your home to a caretaker child, that child that's been living in the house for at least 2 years and provides care to you. Transfer of your home to a sibling with an equity interest. The sibling can either own a part of the house, live in the house, or the sibling can have done work on the house, done repairs, maintain the house, and Medicaid would consider that sibling to have an equity interest. So transfers to a spouse, blind or disabled or minor child, transfers to a caretaker child of your house or sibling with an equity interest of your house is not going to create a look-back period. So when we have assets being transferred from the ill spouse to the well spouse, we don't have a look-back period. What are non-exempt transfers? What are the transfers that do create periods of ineligibility for Medicaid? A gift. Virtually any type of gift that you make will create a look-back period, whether it's an outright gift of assets to your children, your grandchildren, or it's a transfer of assets to a Medicaid trust, that will create the look-back period. However, there is an exception. If you have had a history of making gifts, and let's say, for example, for the last 10, 15 years, you've consistently made gifts to your children and your grandchildren for tax purposes. Well, you could argue to Medicaid that those transfers were for purposes other than Medicaid eligibility. Okay? So again, the transfers of assets are very important. I think I've really touched on long-term care insurance already. I spent a significant amount of time on telling you about the different options of the insurance. If you're going to get a policy, the kinds of things that you want to look at are, how much daily care am I going to get? Is the insurance for a limited period of time? Is the coverage only for 3 years or 5 years? Is there a lump sum? Obviously, getting unlimited coverage for the rest of your life when you need it is critical. You have to look at what the elimination period for the insurance is. In other words, if, for example, you put in a claim, there may be an elimination period of 90 days or 120 days that you have to pay. It's like a deductible. So you pay for the first 90 or 120 days. So that is a factor in how the premium will be structured. As most of you who have long-term care insurance, those of you that have it may know, the premiums have been going up. The insurance companies have been applying to New York State and having significant increases of long-term care insurance premiums. But it does create a valuable buffer. So if you have long-term care insurance and you give away assets and you create the look-back period, at least you know that you have coverage of a certain dollar amount during the look-back period. The Medicaid Asset Protection Trust. It's an irrevocable trust. I've been using this trust for almost 30 years now. I think it is a fantastic planning tool. The way it works is basically, again, you create a trust. You are the creator of the trust. Generally, someone other than yourself has to be the trustee. The trust must require that you cannot receive principal of the trust. So let's say I am a senior and I'm going to be creating a Medicaid Asset Protection Trust, and I want to transfer my house to the trust and some of my savings, not necessarily all of my savings. Very few of my clients transfer all of their savings to the trust. So now I put my house in the trust. The trust gives me the right to live in the house for the rest of my life. The trust says that my house cannot be sold and it cannot be leased without my permission. I have the right to live in the house for the rest of my life. I pay all my bills just like I'm paying now. I get the STAR exemption. I get any senior citizens exemption. If the house is sold during my lifetime, I get to receive the personal residence exclusion, $250,000 excluded from capital gains if I'm single, $500,000 excluded from capital gains if I'm married. But I cannot get the principal back. If I put money in the trust, I can receive the income from the trust. But there is a way of getting the principal out of the trust. There is a way where the trustees can invade the principal for someone other than the grantor, the creator of the trust. They can invade it for the children of the grantor. So there is a vehicle, there's an opportunity to get money out of the trust and get assets out of the trust if it ever becomes necessary to do so. But it's an excellent vehicle because when you die, the house is in the trust. Whatever monies you put in the trust are in the trust. And again, there is no probate. The trust is irrevocable. There is no gift to the trust. There's no gift tax, because in terms of the trust, we reserve a limited power of appointment. We give you the right to change your mind as to who the ultimate beneficiaries of the trust are going to be. We also give you the right to change the trustees. So while you cannot receive the principal of the trust, you do have the power to change your mind as to who the trustees are going to be. You have the right to change your mind as to who the ultimate beneficiaries of the trust are going to be. And believe it or not, I have clients that do this trust even when they're in their 80s. The reason why? Because they want to start the 5-year look back. You want to commence that 5-year look back, and this is the best way of commencing it. Why? Because seniors are very leery about giving money and assets outright to their children. Your children can get divorced. They can get sued. In the divorce, there can be questions about, was the property commingled or not commingled? Was your child entitled to the income from the assets or able to take the assets? It's just not a great idea to make gifts outright to your children. Also, if you were to gift your house outright to your child, and then that child would get the house at your original cost basis. One of the big advantage of doing the Medicaid Asset Protection Trust is that when you pass away, the assets in the trust go to your children at date of death value. Your children get those assets at the fair market value on your date of death. They get what is called a step up in the cost basis. What does that mean? That means that their cost basis is not the price that you paid, it's the price of the house, the fair market value of the house on date of death. And the same applies to any stocks that are part of the irrevocable trust. So when they inherit it, those assets are technically includable in your taxable estate, but because the estate tax credit is so high, $5.85 million in New York, 5.85 in New York, 11.58 million federally, and even if the federal does go down in January of 2026, it's still going to be very close to $6 million per person. So as I said earlier, most individuals are not going to have an estate tax issue. The biggest issue that's going to affect individuals is the cost of long-term care. So how do you get prepared for planning? Obviously, what we like to do with our clients is we ask them that when they come in, we send them a questionnaire so that they can fill out and tell us exactly what the assets are that they have. Provide us with the names of their children. So organizing your affairs, having a list of your assets, knowing what the current value of the assets are, knowing how the assets are titled. Does the asset have a named beneficiary on it? Am I happy with who the named beneficiaries are? So getting your affairs organized is very important. Look at your estate plan as it exists today. Review it, make sure you're happy with it. Look at your power of attorney. Is your power of attorney sufficiently broadly drafted? Does it have a broad gifting provision in it? Many powers of attorney do not have a broad gifting provision. A lot of attorneys, all they do is use the statutory short form power of attorney. Nothing wrong with it, but it does not have gifting powers. So if you're interested in having a further private discussion about this, please feel free to contact me. My name is Anthony Enea. The name of the firm is Enea, Scanlon, and Sirignano. We have offices in White Plains and Somers, New York, and we're more than happy to assist you with your planning needs and making it a specific discussion about your individual planning needs and a plan that's customized to your wants and needs. Thank you very much. Please stay safe and stay in good health during this very difficult time. Thank you.
Thank you so much, Anthony. That was incredible information. Shows really how important all of these things are to get in place. And we do have some questions from our attendees, if that's okay.
Sure.
We got also some people said that this was an outstanding presentation. So That's wonderful. So one question we had is, did you say that a house titled in a revocable trust, not irrevocable, but a revocable trust, is a non-probate estate that Medicaid cannot use to claw back Medicaid
Well,
expenses?
that's a good question. When you die, if you have your house in a revocable living trust, then that house is not a probate asset. However, during your lifetime, if you had to go to a nursing home and you received nursing home benefits, Medicaid during your lifetime can try to place a lien on the house. Because what's going to happen is you're going to be considered, Medicaid can deem you to be in permanent absent status. And if they deem you to be in permanent absent status, they have the ability to file a claim against the house. So even though when you die, it's non-probate, but during your lifetime, they may have filed a claim against the house. So that's an important consideration. The other question?
The other question, thank you for that answer. The other question is, what is the difference between durable and finance POA?
A finance POA is generally a power of attorney that's done at a bank. The financial institution will give you a power of attorney for the specific account, either at a bank or at a brokerage firm. And that's how the finance POA works. Additionally, those powers of attorney are not durable. They may not survive your subsequent incapacity, and they cannot be modified like the durable power of attorney is modified. As I said earlier, in a durable power of attorney, we have a very broad modification section where we put in a lot of provisions that are not gifting provisions in the modification section. And then all the gifting powers are spelled out in the gift rider. And the powers in the gift rider are very, very broad.
Thank you.
Okay.
What you talked about exempt transfers.
Right.
And what if someone is sharing a bank account with a parent or an individual? Is that taking money from that shared bank account? Is that considered an exempt transfer?
What happens is all assets in bank accounts are deemed to own by Medicaid, are deemed to be owned 100% by the applicant for Medicaid. So let's say, for example, my daughter and I have a joint account and my social security number is on the account. Medicaid says that's my account, that's your account, unless my daughter can establish that she deposited money in the account. If my daughter can show that part of the money in the account is her money, then they would not count that money. If I were to transfer that account to my daughter, that would create the look back period for nursing home Medicaid. That would create the 5-year look back. So yes, joint accounts are considered to be owned 100% by the applicant for Medicaid. That's a bank account. If it's a brokerage account, Medicaid has a different rule. In a brokerage account, Medicaid says, if there are 3 individuals on the account, we're only going to consider that the applicant for Medicaid owns 1/3 of the account. That's how they work it on a bank brokerage account. Bank accounts, it's a different and separate set of rules.
It goes to show you how very important it is to meet with someone like you, because each individual family has so many different issues that would come up that you wouldn't know the answer to that. You really need to get into what each individual, their setup is.
You wouldn't know. Are there any more questions?
Yes, we have, how do I get money if assets are in an irrevocable trust?
Well, if you have assets in an irrevocable trust, and I'm only speaking about the Medicaid Asset Protection Trust. There are many different irrevocable trusts. But if you have assets in the Medicaid Asset Protection Trust, the assets can be distributed from that trust to the trustees or to your children or anybody that you named as a beneficiary other than yourself. So if you have a great relationship with your children, the assets can go from the trust to your children. And then once your children have the assets, they're free to do whatever they want with them, including giving them back to you or making a gift to you or paying your bills. So a good relationship with your children is very important when doing a Medicaid Asset Protection Trust.
Great.
The word trust is very important.
It's meaningful here.
Yes.
So double meaning. So I'm going to have a couple more questions if that's okay.
Yeah.
If a child inherits $3 million from a parent and $4 million from an aunt, are they subject to the tax for $7 million, or do they avoid the tax because each is less than the maximum?
Each person that died, their estate would have their own separate tax return. So the person with a $3 million estate, presuming if they live in New York, there is no federal and no New York estate tax if they died this year. And the same with the $4 million. There's two separate estates. The estate tax is not paid by the person receiving the money. It's paid by the estate, right? So you get that money presumably tax-free, but the tax would come out of that money before you received it. But in the case you just described, there will be no estate tax.
Great. And one more question. I'm 56 years old. I just bought a home by myself, and I have a home jointly with my sister. Is it too early to have a trust set up?
Not a revocable trust. It's not too early to have a revocable trust. A revocable trust actually would work very well for you. You could transfer the house that you own into your revocable trust, and you could transfer the interest that you own in the house with your sister to your revocable trust. And then when you die, those assets would pass outside of probate and go to whomever the beneficiaries are that you named in the trust. Okay, so it's a great vehicle for somebody with that kind of, breakdown of assets. It works very well. It would be a revocable trust, not an irrevocable trust. We generally don't do Medicaid planning for people in their 50s, unless the client says to us, look, we have a history of Alzheimer's in our family. My mother died of Alzheimer's at 65. My uncle died of Alzheimer's at 65. And this happens, it sometimes runs in families. And in that case, what we do is we actually start doing the Medicaid planning for that individual in their 50s.
Well, certainly shows the importance of meeting with you and talking about all the specifics that are going on in your life to be able to set up the right plan to protect yourself and your family during this pandemic and beyond. So yes. we're gonna send all of the attendees your contact information so that they can reach out.
Right.
And
we're going to send them an article that kind of summarizes a lot of the things that we talked about as well. If we have your email address, we'll send you an article, and we'll be able to keep you informed about what it is, so you can see it more on paper and have the ability to review it again. And again, if you have any questions, you're more than welcome to give us a call.
Well, thank you so much for your generosity of time and information. This was incredibly valuable to all of our participants and to me as well. Everyone really had phenomenal questions. So thank you all for attending and for your questions. And keep an eye out for the article and contact information so that you can make sure that you are protecting your family during the pandemic and beyond. Have a wonderful day and a wonderful Memorial Day weekend.
Yes. Great Memorial Day weekend. Take care. Bye-bye.
Bye-bye.